Okay, let's dive right into this by putting you directly in the shoes of the accused. Imagine doing something completely legal today. You go to sleep, wake up the next morning, and suddenly, bam, you're arrested for it simply because a new law passed overnight. Your entire life just upended by a rule that literally didn't exist when your head hit the pillow. Sounds absolutely terrifying, right?
Well, welcome to this explainer. Today, we're going to demystify a really fascinating tension in criminal law. We're exploring the strict, forward-facing timeline of criminal liability and its one remarkable backward-bending exception. It's a journey deep into Articles 21 and 22 of the Revised Penal Code, and this tension fundamentally defines exactly how justice operates when time and the rules of the game collide.
So here's our agenda for today. First, the rules of the game. Second, Article 21, the bedrock rule. Third, banning ex post facto. Fourth, Article 22, favorable retroactivity. And finally, changing laws mid-trial.
Let's kick things off with Section 1, the rules of the game, understanding the boundaries of penal laws.
We're going to chart a clear path today, starting with the rigid rules that protect citizens from state power, before we introduce a major plot twist later on. Think about this just like in sports. You can't be penalized for a rule the referee just invented after the game has already ended, right? Well, in the Philippines, there's no such thing as common law crimes. This means you can't be punished just because society generally thinks what you did is morally wrong or because it goes against some long-standing tradition. Unless a specific statute, like the Revised Penal Code or a special penal law formally passed by the legislature, explicitly defines and punishes an act, there is absolutely zero criminal liability. The rule has to be clearly written down in the books first before anyone can be held accountable to it.
Moving right along to Section 2, Article 21, the bedrock rule, prospective criminal law.
This foundational concept brings us directly to Article 21 of the Revised Penal Code, which states, "No felony shall be punishable by any penalty not prescribed by law prior to its commission." So, the absolute crucial point here is that the state is announcing its policy. You cannot be subjected to a penalty unless that specific penalty was already prescribed by a published law before you acted. Criminal laws look forward. They do not look backward. They are strictly prospective in nature.
And this rule acts as a strict guarantee to the citizen. As highlighted in the landmark case of U.S. versus Perone, it ensures that we're safe from arbitrary, after-the-fact government prosecution. Think about it. Without this strict guarantee, the government would hold the terrifying power to arbitrarily prosecute you after the fact based on changing political winds or sudden moral panics. The state cannot define a crime today and use it to lock you up for something you did last week. It's a fundamental safeguard of your liberty, ensuring that everyone knows exactly what the rules are before they step out into the world.
Which leads us perfectly into Section 3, banning ex post facto, the constitutional shield.
To really reinforce Article 21, the Bill of Rights in the 1987 Constitution provides an ultimate constitutional shield by explicitly banning the state from ever passing an ex post facto law. So what is that? Essentially, an ex post facto law is any retroactive law that prejudices or hurts the accused. The Constitution bans this across three very specific scenarios. First, it bans making an innocent act criminal after the fact. Second, it bans aggravating a crime, which basically means making a past offense legally worse than it originally was. And third, it bans inflicting a greater punishment than what was allowed when the act was originally committed. In all these cases, the Constitution gives a hard, undeniable no.
We can actually see this perfectly applied in the real world with the case of People versus Villaraza. Picture this scenario. The accused committed the crime of estafa, specifically involving bouncing checks, way back on October 16, 1974. Fast forward an entire decade, in October 1985, a new decree was passed that significantly increased the penalty for bouncing checks. Believe it or not, the state actually tried to apply this new, much heavier 1985 penalty to the 1974 crime. That is an 11-year gap. The court, rightfully so, struck it down. Applying that increased penalty retroactively to an act committed over a decade earlier was completely prohibited because it operated as an ex post facto law.
All right, on to Section 4. Article 22, favorable retroactivity, the exception to the rule.
Now that we've established the absolute bedrock rule that laws only apply to the future, here is the massive plot twist. While Article 21 strictly looks forward to protect you from the immense power of the state, Article 22 is actually totally willing to reach back into the past. But, and this is a big but, it will only bend backward if it is lenient and favors the accused.
Here is the exact wording of Article 22. It says, penal laws shall have a retroactive effect insofar as they favor the person guilty of a felony. This means if a new law or an amendment is passed tomorrow that actually reduces the penalty for an act you committed yesterday, you get to benefit from it. Let's say, for example, an offense carried a 10-year sentence yesterday when you committed it. But today, the legislature passes a new law reducing the maximum sentence for that exact same crime to just 5 years. Because of Article 22, the state bends backward to give you the 5-year term. The accused can invoke this new, more lenient law retroactively to get a much lighter sentence.
But of course, this leniency has specific rules. So who actually benefits? Well, any person guilty of a felony. Remarkably, this applies even to convicts who have already been given a final sentence and are currently serving time in prison. If a new, friendlier law passes, their sentence gets reduced and they might even walk free early. However, there is one massive exception: habitual criminals. A habitual delinquent is someone who has been repeatedly convicted of specific crimes within a set period. Why are they excluded? Because the state reserves its mercy for those who have made a mistake, not for those who show a constant, calculated disregard for the rules. Habitual delinquents are strictly excluded from getting this lucky break.
And finally, Section 5, changing laws mid-trial, the duty of the courts.
So, what actually happens in the courtroom when the legislature changes the laws mid-trial or while someone is already sitting in a prison cell? Well, if a penal statute is entirely repealed, it doesn't automatically mean a get-out-of-jail-free card. We have to look really closely at what the new law actually says. If the new law still considers your core conduct illegal, meaning it wasn't completely decriminalized, just kind of repackaged under a new statute, you are still liable. You don't just get to walk away. However, if that new law introduces any favorable changes in the penalties, those specific lighter penalties absolutely must be actively applied to the defendant's advantage.
And here's the best part. The courts don't just sit back and wait for a defense attorney to notice the law changed. As established in the doctrine of People v. Moran, the courts have a proactive, mandatory duty to apply this favorable retroactivity automatically, entirely on their own initiative. The Supreme Court essentially ruled that Article 22 would be completely useless if courts didn't fulfill this duty. So even if the accused or their lawyer totally forgets to ask for the lighter penalty, the judge is legally required to apply it anyway. The justice system itself is enlisted to ensure the accused receives the benefit of the state's leniency.
To wrap up this explainer, I want you to consider this delicate balance. If the state has the absolute power to punish, why does it mandate mercy when the rules of the game change? The state has immense police power, right? The authority to take away liberty, define crimes, and impose harsh penalties. Yet, through Article 22, it binds itself to a really remarkable standard of fairness. The law only bends backward if it serves human leniency. It's a profound reminder that justice isn't just about rigid punishment. It's also about mandating mercy when the rules of the game change for the better. Think about what that says about the very foundations of our legal system. Thanks for learning with me today, and I really hope this provided a totally new perspective on how our laws operate.